The Americans with Disabilities Act provides essential protections for millions of Americans in the workplace. But many people don't know how to access these rights or what to do when facing discrimination. The ADA is a comprehensive civil rights law enacted in 1990 that prohibits discrimination against individuals with disabilities in all areas of public life, including employment, education, transportation, and all public and private places open to the general public. To qualify for ADA protection, you must meet specific criteria. The law defines a person with a disability as someone who has a physical or mental impairment that substantially limits one or more major life activities, has a record of such an impairment, or is regarded as having such an impairment. This protection extends to those associated with individuals with disabilities as well. Title I of the ADA specifically addresses employment and applies to private employers with 15 or more employees, as well as all state and local government administrations, employment agencies, and labor unions. Some states have additional protections that may cover smaller employers. Applying for ADA protection doesn't require a formal application process. Instead, it begins with notifying your employer about your disability and requesting reasonable accommodations. This notification should clearly describe your condition and how it affects your ability to perform job functions. When requesting accommodations, be specific about what you need. Reasonable accommodations may include modified work schedules, changes to policies, installation of new equipment, creating a more accessible environment, job restructuring, reassignment to another position, or providing interpreters. Common examples include ergonomic workspaces with adjustable desks and specialized keyboards, assistive technologies like screen readers or voice recognition software, flexible hours or remote work options, and physical modifications to the workplace, such as ramps or wider doorways. Employers must engage in what's called an interactive process to determine appropriate accommodations. They are required to provide these accommodations unless doing so would cause an undue hardship, meaning significant difficulty or expense relative to the size and resources of the business. Your privacy is protected under the ADA. Employers cannot ask about disabilities or require medical examinations before making a job offer. After an offer is made, they may conduct medical exams only if required for all employees in similar positions. During employment, medical inquiries must be job-related and consistent with business necessity. All medical records and disability-related information must be kept confidential and stored separately from general employee files. This confidentiality is crucial for protecting your privacy and preventing discrimination. If you believe you've faced discrimination due to your disability, you have several options. First, document everything, including dates, times, people involved, and what happened. Report the issue to your company's Human Resources Department to attempt resolution internally. If internal resolution fails, you can file a formal complaint with the Equal Employment Opportunity Commission, or EEOC. This must be done within 180 days of the discriminatory act, though this deadline extends to 300 days in states with their own anti-discrimination laws. The EEOC may offer mediation as an alternative dispute resolution method. If mediation is unsuccessful or declined, the EEOC will investigate your claim. Based on their findings, they may attempt to reach a settlement, issue a right-to-sue letter, or take legal action against your employer. The ADA often overlaps with the Family and Medical Leave Act, or FMLA, which allows eligible employees to take up to 12 weeks of unpaid, job-protected leave annually for specific family and medical reasons. While FMLA leave is limited to 12 weeks, ADA accommodations might include additional leave time if it doesn't create undue hardship. Many states and localities have enacted their own disability protection laws that may provide stronger accommodations requirements, expanded coverage for smaller employers, or additional protections beyond federal regulations. Check with your state's Department of Labor to learn about these additional protections. Remote work has become increasingly common, and the ADA requires employers to provide reasonable accommodations for employees working from home. These may include adaptive software, adjusted work schedules, ensuring digital accessibility, and providing specialized equipment. Understanding your rights under the ADA is the first step towards securing the accommodations you need to succeed in the workplace. If you're unsure about your specific situation, consulting with an attorney who specializes in disability law can provide personalized guidance for your circumstances. By knowing how to properly request accommodations, document discrimination, and take appropriate action when necessary, you can effectively advocate for yourself and ensure your rights under the ADA are protected.